Today we're going to talk about speeding. I'd like to keep you out of jail. However, my guest today, Kevin Unger with the Ticket Wizard, would love for you to go to jail so that he can collect your money and save you from some of the new laws that have come into place.
I wouldn't like them to go to jail, Laura. I'd like to keep them out of jail.
Yes. Right, but they got to create the crime and the possible doing the time, and that's how you keep them out.
Well, I'll do my best to be their best advocate. I think something that just came up, the legislature in the state of Florida decided that as of July 1st, if you are speeding and you're driving over 30 miles an hour over the limit, you could be considered for a crime, and that's a misdemeanor. Before July 1st, if you were speeding or alleged to be traveling in excess of, let's say, 50 miles an hour over the limit, or over 100 in a 70 or 100 in a 65, they would just give you a ticket for, let's say, 165, that's 35 over. Sir, here's your ticket, goodbye, have a nice day. Okay, they wouldn't arrest you. In theory, they could have arrested you because they could charge you with reckless driving if your speed is in excess of, let's say, 30 miles an hour, but in the past they didn't. If you're accused of a DUI and you give a breath sample, what would happen is that you're giving the state evidence to use against you, but your license suspension for a first offense would be less. And specifically, that first license suspension would be a 6-month driver license suspension for a DUI if you blew above a .08 but under a .15. If, on the other hand, you refused to give the state of Florida a breath sample, now your punishment is going to be a 1-year driver license suspension, because when you look at your license, if you look on the very bottom, you're going to see that it says you consent to any sobriety exercise.
Hi everyone, welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week we talk about something that will help you make a little money, save a little money, or maybe just help you navigate this crazy world that we live in. Today we're going to talk about speeding. You're probably like, what does this have to do with anything? Well, I'd like to keep you out of jail. However, my guest today, Kevin Unger with the Ticket Wizard, would love for you to go to jail so that he can collect your money and save you from some of the new laws that have come into place.
Well, I wouldn't like them to go to jail, Laura. I'd like to keep them out of jail. Yes.
Right, but they got to create the crime and the possible doing the time, and that's how you keep them out. So.
Well, I'll do my best to be their best advocate. So I think something that just came up, the legislature in the state of Florida decided that as of July 1st, if you are speeding and you're driving over 30 miles an hour over the limit, okay, you could be considered for a crime, and that's a misdemeanor. So let me just, if it's okay with you,
absolutely.
The state of Florida just enacted statute 316.1922, which states, it's called the dangerous excessive speeding statute, or the super speeder law as they refer to it. And basically, if someone is in excess speed of over 50 miles an hour over the legal limit, or on any highway at over 100 miles an hour, you would be considered a super speeder. And you can be charged not as a speeding ticket, but as a misdemeanor, which is a crime. And so these are things that people weren't aware of, and they need to be aware of when they do drive on the roads. That now, if you are in excess of 30 miles an hour, in theory considered like 100 on a 70, or if you are in excess of 100 on a 70, or let's say, for instance, if you're on a University Drive and it's a 45 and you're going 90, and people, believe it or not, do crazy stuff like that,
yeah.
And or 95, you can be considered, that's 50 over, and now you could be arrested on the spot. This is a significant change to the Florida statutes.
So before you get pulled over, they'd give you a ticket for going 50 over, and that was it. You just paid.
Okay, in the past, so what would happen is, if you were, before July 1st, if you were speeding or alleged to be traveling in excess of, let's say, 50 miles an hour over the limit, or over 100 in a 70 or 100 in a 65, they would just give you a ticket for, let's say, 165, that's 35 over. Sir, here's your ticket, goodbye, have a nice day. Okay, they wouldn't arrest you. In theory, they could have arrested you because they could charge you with reckless driving if your speed is in excess of, let's say, 30 miles an hour, but in the past they didn't. They
okay, but reckless driving, though, could still be considered a misdemeanor, right?
Okay, well, reckless driving is a misdemeanor.
Okay,
so the speed alone usually is not a misdemeanor up until July 1st of 2025. The legislature decided that a speed in excess of roughly over 100 or in excess of 50 miles an hour would be automatically a misdemeanor now, where in the past it was discretionary with the officer.
Oh, okay.
The reason why I mentioned reckless driving is years ago I was in court and a judge happened to be talking to a prosecutor, and the judge asked the prosecutor, when the person was alleged to be traveling over 30 miles an hour at that time, why didn't you just charge him with reckless? And the prosecutor said, I guess I could have, but I didn't. It could be considered reckless. Reckless is an opinion crime, like a DUI, but a reckless driving charge usually has such things as weaving in and out of lanes, high rate of speed, no directionals, or
so just going
abrupt,
straight 40 miles, 30 miles over isn't necessarily reckless. It's just high speed. So that's the discretionary part.
Correct.
Where instead, where they're weaving in and out, which we get those people racing, that's reckless.
100%. And then the other thing that you should be mindful of now, though, is after the statute change on July 1st, now speed in excess of 50 miles an hour over the limit, or in excess of 100 miles an hour over on, let's say, the Turnpike or I-95, now is considered a super speeder, and they could be arrested on the spot. So let me just further discuss this. If someone is alleged to be traveling 100 over, let's say on the Florida Turnpike, so the first offense would be up to 30 days in jail if they're caught, with a $500 fine plus costs. A second or subsequent offense would be up to 90 days in jail and a $1,000 fine. So the state of Florida is making speeding an enhanceable crime if you're caught over 30, like with 100 and a 70 or 165.
But it's not 30 and 500. It is 30 and 500. It's not 30 or 500, right?
Okay, so let me explain. So just to be clear, if someone's traveling 100 in, let's say, a 70, okay, that would be considered a super speeder, okay? So that's one example of it.
And you're automatically arrested.
Not automatically, but it's discretionary, but the officer could arrest you just for that alone.
Okay.
With no other, I'm going to say, traffic pattern other than just a high speed. You could be arrested on the spot.
But, okay. And so, you're not necessarily going to be arrested, but you are definitely going to have a misdemeanor.
100%. As of July 1st.
That's the difference.
Anything over 100, you're going to be charged as a misdemeanor or a misdemeanor with a crime, and anything 50 over for sure is going to be considered a crime. So these are new changes that the Florida legislature thought was important. And being candid with you, since COVID, there's been a lot of what would be considered more aggressive driving out there, and so I think, whether real or imagined, the Florida legislature is trying to put a stop or an end to this and make the roads a little bit safer.
Okay. So that's one change. Any other changes? Nothing off the top of your head, because I do have my favorite topic.
Okay, I will address your favorite topic of DUIs, or whether to
blow or not blow.
Okay, and that would be considered, if you give a breath sample for a DUI case, that would be considered a do ball or a breath sample case, and usually that would be anything over a 0.08 would be considered impaired, and then above a 0.08 would be considered a 0.15 would be considered an enhanceable DUI, and you would get harsher punishments for that if you gave a breath sample. Whereas if you refuse to give a breath sample, now that's a different circumstance, and while you're giving the state less evidence to use against you in a refusal case, the punishment will be harsher. So let me give you an example of punishment. If you're accused of a DUI and you give a breath sample, okay, now what would happen is that you're giving the state evidence to use against you, but your license suspension for a first offense would be less. And specifically, that first license suspension would be a 6-month driver license suspension for a DUI if you blew above a 0.08, but under a 0.15. Okay. If, on the other hand, you refused to give the state of Florida a breath sample, now your punishment is going to be a 1-year driver license suspension, because when you look at your license, if you look on the very bottom, you're going to see that it says you consent to any sobriety exercise. Okay, I can read it if you want the exact terms.
No, that's okay.
But basically, go ahead.
Okay, so let's step back for a second, right?
Yes.
So you have a client, they've refused now to blow. Automatically they lose their driver's license. On their record, does it say DUI?
Of course. So, okay.
Okay, I'm just curious, because obviously this can matter for people's future for jobs.
Okay, so let me explain. So, to repeat your question, you asked if someone is accused of a DUI and they get pulled over and they're issued a DUI citation, correct? Is that what you're saying? Okay. And then you're asking, Would that appear in their driving record or their abstract?
No, they've refused to blow. So how do you know that they have a DUI? They just don't
Okay.
want to. They feel like, oh, I don't want to blow, even though they signed their driver's license, right?
Okay, so what would happen is that on the spot, the law enforcement officer would take their license, whether they give a breath sample or not. However, what would happen is the officer would mark the DUI ticket as a refusal, and that would go on your permanent driving record. And the only way to beat the refusal or to beat the DUI is to try it. Okay, if you tried the case and won, then in theory, your DUI would come off your record, but the refusal most likely would stay, because this is a little confusing, but I'll try to explain it. Anytime you have a DUI case, there's really two parts to the case. There's the administrative part, that's the part that deals with the Driver License Bureau, and the judicial part, that's the part that deals with the court system. So the first part of the DUI case is with the administrative part, and that's with the DMV. So in theory, if you tried to get whether it's a refusal or the breath sample off your record at that early stage of the case, you would have to contest your hearing at the Bureau of Administrative Reviews, which is like a little division inside the DMV that hears DUI cases. Okay, the problem there is that those cases are very difficult to win as an advocate, because the burden of proof in an administrative hearing at the DMV is something very low, called a preponderance of the evidence. And that means that it's more likely than not, it's reasonable suspicion, I believe.
Okay.
And that's a lower burden. That's a lower burden that you were under the influence of alcohol or drugs at that time. Okay? So the burden for the DMV to prove that you were under the influence is a lower burden than, let's say, in a court of law where it's beyond a reasonable doubt. Okay?
So what's easier
Which is
for
a
you
high
to
burden.
try? One that refused or one that gave?
Okay, so as an advocate for people accused of DUIs, while both have different ways you can attack the state's case,
We can't give all his information out.
not in a 30-second show or a 30-minute show, Laura, at least give me an hour, okay? But basically, a refusal would be, if you're just saying average case to average case, a refusal would be easier to fight because you're not giving the state evidence. And the evidence would be what your breath sample was. So to give you an example, if you gave a breath sample to law enforcement at the time of your DUI arrest, a 0.08 would be one level of impairment. And then if you had a 0.15 or above, not only that would be an enhanced punishment, but there's additional penalties there, and it's harder to beat a case when you blow that much higher. Does that answer your question?
It does. It
Okay.
does. But if you really only had one drink and you're 0.08 or less, is
Yes.
it better to blow?
Okay, so
Do I blow or do I not blow? And I know it's hard to give these answers and you don't want to be construed as giving, advice, but I'm asking for a friend.
Okay, so I would tell your friend this. The best advice I would give your friend is, if you plan on drinking at
Don't
all,
drive.
please do not drive. That's the best advice, and
But
that's
let's
for
just
free.
say a friend doesn't listen and they still drive.
Okay, so then,
And they only had one drink, but they're fixing their hair or doing whatever, and next thing you know, they get
Okay.
pulled over.
so the problem with answering your question is that everybody's body style is different, everybody's metabolism is different. So you don't know if one drink would, quote unquote, push them over the legal limit
No, I get
or
that.
not.
But let's just say
Okay.
that it was one drink and it was 2 hours ago, right?
Mm-hmm.
But you get pulled over. They're asking you to blow. You know it's been a while. You feel fine. What do you do?
Okay, so first I have to advise you that the term drunk driving is not really the legal term. It's impaired driving, and there's a difference. People often come to me and say, but I wasn't drunk, and I was given this DUI ticket. The level of scrutiny is not drunk, it's impaired. Drunk is fall down. Most people aren't fall down with a DUI. Most people are impaired. So when you say to me, if someone had one drink, okay, would that make them impaired? That's being candid with you. That's a question that everybody's body would answer differently. As a lawyer, if you look at your license, it says you agree to any sobriety exercises. So if you're asking me as a lawyer and you're saying, well, what should I have done? So I would always say to you, comply with the law, because a lawyer has to follow the law. Even an advocate like me who handles traffic and criminal defense, I have to advise you always as a potential client and friend that I would want you to follow the law. I would also advise my clients.
But I'm hearing mixed.
Go ahead.
I'm hearing mixed stuff. So let's go to commercial break when we come back, because I'm hearing mixed stuff from you, and I'm just saying. So let's go to commercial break. Let's check out our sponsors, and we'll be right back.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
Priority One Credit Union of Florida is a welcoming credit union that makes your financial success our number one priority. We offer lower loan rates, higher deposit rates, and common sense local loan approvals, with nationwide access through shared branching.
Hi, I'm Dina Hennessy, President and CEO at Priority One Credit Union. We are open to the community. Anyone can be a member of our credit union, and we would love to have you.
Contact us today at 954-335-5100. You can also reach us at PriorityOneFL.org. Your financial success is our priority. That's 954-335-5100.
Hi, everyone. Welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. Today, we're talking about anything that has to do with traffic violations. So I'm here with Kevin Unger from The Ticket Wizard, formerly Unger & Coet.
Correct.
Right? And we're talking about, should I blow or should I not blow? And we're talking about DUIs. Let's be very clear. Okay, so we were talking, and I said, I feel like we're not getting a clear answer, and that's okay because you are a professional and you have to be very careful about the information provided. I understand that. And I got earlier on in the conversation that I shouldn't blow. And then I got later on, well, I am, a professional that needs to tell you that you signed a document when you were like 16 that says, right, like who read that, right? That says that if you get pulled over, you're obligated to blow. So if I blow and I'm under 0.1,
0.08.
No, because
Okay.
I think 0.08, it's going to be 6 months, right? But if it's over that, I'm sure it's not 6 months, right?
Well, between 0.08 and 1.15, excuse me.
Yeah,
So
it's 6 months. But
it's 6
anything
months.
after
Then it's
0.15,
enhanced. Then
which
you get
means
enhanced.
you
Go
might
ahead.
lose your license for,
A longer period of time.
right.
So that's discretionary with the state. So if you blow above a 0.15, which is close to double the legal limit, then you should expect an enhanced punishment if your case gets resolved that way, or if a jury would find you guilty of the offense of DUI enhanced.
All right, so we were talking in the break and you were talking about the difference between pouring a house drinks, I'm at somebody's home party, and whether or not to go to the local sports bar, right? You're saying that typically a house pour would be a little heavier. So let's put that to the side for a minute, because I know that can take into consideration. But I'm 150 pound, I wish I was 150 pound. I'm 150 pound female, right?
Like, I'm going to get involved with the weight discussion.
Yeah. I'm
looking at you. Go ahead.
I'm 150 pound female in my
ahead.
mind. I've had 2 glasses of wine.
Mm-hmm.
That's a normal pour.
Okay.
I have not eaten dinner, but I had lunch at 12. It's now 7 o'clock at night. I'm driving home. I had those wine from 5 to 7. Now I get it. There's a lot of information. There's a lot of different things that can come into play. I'm just using something very basic. How likely would I blow more than 0.08?
Okay, so I think your question is excellent, because a lot of people would ask something similar to that when they come into my office. So the first thing you have to ask a client is, when was the last time you ate? Obviously, you want the food to absorb the alcohol, okay?
Right.
Now, I'm not a chemist, and I can't say for sure, and I have to be candid with you. Everybody's
Metabolism.
body metabolism is different. Everybody's height and weight is different, and how you...
Oh yeah, that's right, because I have to say I'm 5'5". I'm not just 150 pounds, right? I'm not 5'9". Because that's 5'9" and 150 pounds. I think that would be less weight and putting more liquor into it, right? Because I'm taller.
Well, I understand. So I'll answer your question with a comment and then maybe another question. And respectfully, if you said to me, I'm going to change the topic, but I'm going to come back to your point.
Okay.
If you said to me, what's the stereotypical DUI that comes into my office today? I would say to you, well, what would you think it would be? What's the stereotypical client?
I think the stereotypical man would be a man. I think it would be a man that's probably just under 6 feet, weighing somewhere around 225 pounds. I'm guessing, right? And had 5 beers.
Okay. So
Am I off?
I think you are.
Oh, so it's a woman. Okay.
So the stereotypical client in today's modern times is a lady who is in between age 35 and 50, who had exactly
I'm
what you
almost
said.
out of this.
It's a person who, in your fact pattern, would have had 2 drinks. It's a girls' night out. They came from work. They had a couple of drinks, and then they decided to go home. And the problem is that oftentimes 2 drinks out could be enough to push you over a 0.08. The other concern I have is, and this is very common in today's times, is a lot of people take what would be considered Xanax, and it's lawfully, they're taking it lawfully, but they're prescribed medication. And what happens is, when you have 1 or 2 drinks and then it mixes with the alcohol, oftentimes you're way over a 0.08. It's not even close. And that's, believe it or not, the stereotypical client in my practice is a woman aged 35 to 50, went out with their friends just to have 1 or 2 drinks after work, nothing big, and that's what happened. They got into a DUI.
Now you can answer this, not answer this. Just what's the typical retainer for something like that? Because I think that obviously you're going to say an Uber is much cheaper than the retainer fee.
Yes, it is.
Because I know you don't make your money on the traffic tickets.
Okay, so I can't give you an exact answer, but I'll give you a range.
Okay.
So what happens is that oftentimes when someone comes in, we're going to ask them, did you give a breath sample? Did you not give a breath sample? We're going to review how their DUI occurred. Was this an accident-related incident? And when there's an alcohol-related incident, such as an accident, then obviously the legal fee to represent them would be more. You're hoping that if it was an accident, that there was only property damage as opposed to bodily injury. If you have bodily injury in a DUI, you're looking at a felony case now. So those fees can be in excess of $7,000 if it's an accident with injury, and you hope that it's not a serious bodily injury accident. So let me explain why I use the term serious bodily injury. In the state of Florida, that's another legal term. Serious bodily injury means a disfigurement, a break, a permanent scar to some extent. So when someone suffers, let's say, a broken wrist or a broken hand in an accident, even though, let's put it this way, that all of a sudden gets the attention of the state of Florida, and whether it's DUI related or not, if you are involved even in a regular, just an unfortunate car accident and someone has a serious bodily injury, they're looking at a minimum of a 90-day driver license suspension, and it could be more depending on, what the judge hears and the facts of the case. And by the way, let's say if you're in an accident and it's unfortunate and someone passes as a result of the accident, but there was no criminal conduct. And what I mean by no criminal conduct is it was just an unfortunate, terrible accident, like a motorcycle crash and someone passes as a result of that. So then the minimum amount of punishment is 6 months of driver license suspension in addition to a $1,000 fine for a fatality accident, a fatality case. So those are very serious, and the state of Florida treats them seriously and levies a punishment accordingly.
And can you believe that we are running out of time? So, what is the best way for anybody that is any kind, whether it be a speeding ticket, say DUI,
Speeding ticket, red light, U-turn, DUI, suspended licenses. We can help you with all these types of problems, and we can help you not only in Broward, Dade, and Palm Beach County, but we can help you statewide with a traffic or criminal matter. Can I give my phone number?
Yes, give them your phone number.
Our best number to reach us at is 954-370-9999. That's 954-370-9999.
And that's really easy to remember. So next time, if you get pulled over or you get a DUI and you can't remember to call 954-370-9999,
Very good.
then call Laura Sanders. Remax Direct will be more than happy to connect you to Kevin because he's great. He's been very helpful. My son's been in a car accident.
Confidential. Shh.
I have personally had a stoplight or, red light, whatever, which I'm still waiting for that.
Confidential.
So give me a call, Laura Sanders, Remax Direct, 954-650-0827. I know it's a little bit off topic for real estate, but in the end, realtors, we're driving every day. We're getting tickets. We need to know that when we do go out to that happy hour for the board, that we do sometimes make mistakes and we need to have representation. So again, don't forget your favorite realtor, Laura Sanders, Remax Direct, 954-650-0827, or check me out on the web at lauracell.com. And if you get pulled over for a ticket, DUI, U-turn, suspended license, speeding ticket, definitely give Kevin Unger a call at 954-370-9999. Did I get that right? 370-9999. And they have other offices all throughout the counties, and they are bilingual. And again, thanks for listening to Laura Sanders with Making Money with Laura Sanders.
Thank you for tuning in for Making Money with Laura Sanders, a name you can trust. To join the conversation, call us at the studio, 888-994-4995 Studio A, or contact Laura directly at 954-650-0827. Laura Sanders, a name you can trust. We